Hello, this is John Milburn for PROP13001 Property Development. We're into week 11, and this week we deal with sustainable development. So when we're dealing with sustainable development, usually we're talking in a global sense, we're talking in a macro sense, and how the community can work towards a sustainable development process that works for the greater good. We want to keep that firmly in mind, and most of the legislation that we deal with in tonight's session deals with that topic. However, there's a more acute, if you like, reason for developers to consider the topic of sustainable development, and that is that by adopting the principles of sustainable development, the property developer has an opportunity to reduce waste, which will save money, and at the same time, win-win, reduce environmental impact. So in the context of a property developer considering the question of sustainable development, I want you to consider how the property developer can avoid litigation, can avoid unnecessary cost, can minimize waste, and all of this requires an efficient waste management strategy that has the result of also providing a sustainable development. From your reading, you'll know that the principal pieces of legislation that you need to consider for this week is in Queensland, the Planning Act 2016, and that's supplemented by the Planning Regulation 2017. In the event of a planning issue becoming litigious, it's likely that you as the property developer will need to consider the Planning and Environment Court Act of 2016. They're at a state level. At a federal level, consider the Environment Protection and Biodiversity Conservation Act, the EPBCA. And at a wider level, in terms of international obligations, you might consider, perhaps almost as a starting point for your reading, a couple of things. The first is the United Nations Conference on Sustainable Development, United Nations, Rio de Janeiro, on the 20th to the 22nd of June 2012, which is called Rio Plus 20. And the reason for that reference is that the original conference on sustainable development occurred in Rio de Janeiro in 1992. So hence the Rio Plus 20 conference in 2012. At a state and federal level, an important thing that came as a result of that conference was the Intergenerational Agreement on the Environment from 1992, and that is relevant in terms of the way that agencies work together in terms of monitoring and regulating sustainable development principles. There are some reference materials that I've provided to you in this week's study guide that point you to outside agencies that are highly influential in terms of this area of practice. So, for example, you'll see the link to the Green Building Council of Australia, and in that you'll see a case study, which is to do with the Commonwealth Bank Place. Case studies are important because they provide you with some insight as to how these theoretical principles are applied in practice. So please consider the case study and consider the legislation that influences the Sustainable Development Project. So as I mentioned, the historical background to sustainable development can in many ways be traced back to 1992, to Rio. But even before that, as far back as the 70s, political pressure was coming to bear on lawmakers to consider the environment in the context of other laws. Now, there was a fundamental problem here for the Commonwealth government, and that is that when the Constitution was enacted and the powers which were conferred upon the Commonwealth government through the Constitution were considered, and in that regard primarily refer to Section 51 of the Constitution, there was no concern or thinking about the environment as an area of practice. It's a new area of practice. So how could the Commonwealth government enact environmental laws to deal with issues of sustainable development if it had no power to do so? Well, in effect, it relied on other powers, and after a series of challenges through the 80s, the Commonwealth and the states collectively decided to work cooperatively rather than to compete with each other. And that led to the Intergovernmental Agreement on the Environment in 1992. So that gives you some background as to why we have this duality, if you like, of environmental laws, both at the Commonwealth and state level. In fact, it goes beyond that, because you'll be aware that in dealing with issues to do with sustainable development, local councils will also regulate and provide policy and guidelines, decisions, in fact, that relate to sustainable development issues. You'll see now that throughout the documentation that you need to consider as a property developer, there will be consistent reference to sustainable development. So it flows from the legislation through to the executive, and you may be dealing at the executive level with applications and decisions made by the executive branch of the government. The executive has the power, in fact the responsibility, to regulate environmental activity, which is power conferred upon it through Parliament. So Parliament delegates the power to regulate environmental activity, sustainable development, to the executive branch of the government. The state government delegates that to councils. So if you're challenging any decisions that have been made and you're not comfortable with it, one of the first things that you might consider is whether the decision maker does in fact have the power to make the decision that he or she purports to make. That means looking at the legislation, looking at what power was delegated, and then asking whether that power was properly exercised within the context of that delegation. So have a look at the Planning Act, have a look at the EPBCA. In both instances, you'll see that there are objects which relate to the desire to maintain sustainable development within property development. And in the EPBCA, for example, in Section 3, there are a number of objects that have a bearing on sustainable development. And one of those is the obligation on governments to promote an ecologically sustainable development through the conservation and ecologically sustainable use of natural resources. The Planning Act also refers to the desire to have sustainable development as a centrepiece of the planning system. If you look at the long title to the Act, it says, amongst other things, that the role of planning and development assessment is to facilitate the achievement of ecological sustainability. You might look at this and ask yourself then whether you are prepared as a property developer to embrace sustainable development as a principle, or whether you're going to fight against it. But before you decide to fight against it, make sure that you're aware of almost the flood of material which is legislated now that requires decision makers to keep sustainable development, particularly ecologically sustainable development, in the forefront of their minds. I mentioned the EPBCA, Section 3. Have a look at 3A, which deals with the principles of ecologically sustainable development. And you'll see there are a number of principles that flow from that general overarching principle. For example, there's an obligation for government decision makers to consider whether threats of serious or irreversible environmental damage should be considered. And in that regard, the Precautionary Principle says that lack of full scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. You can read more about that both in the study guide and also the legislation. In the study guide, we also have some commentary in relation to the Intergovernmental Agreement on the Environment, as I mentioned, from 1992, and some of the goals that are established there. So when we're talking about sustainable development, the question becomes, what do we mean by ecologically sustainable development? There are a number of definitions that you might consider. One of the early ones from 1987 is from the United Nations World Commission on Environment and Development report, which says that sustainable development is development that meets the needs of the present without compromising the ability of future generations to meet their own needs. So you might say, why as a property developer do I need to know this stuff? Well, part of the reason is know where it's sourced, know why it's sourced, know why you need to consider it when you're making an application for a property development approval or you're fighting in relation to conditions. That means that armed with the knowledge of why you need to embrace sustainable development process, it gives you an opportunity to argue for or against certain things that work to or against your advantage, as the case may be. In other words, if you can incorporate principles of sustainable development in an application, in my view, you're more likely to have that application approved, or if you can argue issues of sustainable development, it may mean that you have an opportunity to remove conditions that are adverse to your interest. One of the big ones is the precautionary principle. It's a recognised principle. It's reflected in policy, case law, and indeed some legislation. It's a growing area of practice, and you need to be mindful of it. So there are two conditions that trigger the precautionary principle. The first is that a threat of serious or irreversible environmental damage exists. And secondly, scientific uncertainty exists as to whether or not there is a likelihood of damage. Have a look at section 3A of the EPBCA, and also have a look at section 391, which in the context of the EPBA says that the Minister may take into account the precautionary principle in making decisions. Now, I appreciate that we're talking about property development at a high level now. When we're talking about the Minister being involved in that process, we're probably talking about major resorts as property development, not so much issues that require building and development approval in a day-to-day fashion for a small subdivision or a small development. However, you need to be aware of these things irrespective of the size of the development. Also be aware that in exercising powers to oversee environmental activity and sustainable development, governments may choose a variety of regulatory tools to ensure compliance. In this regard, you need to be aware of the Environmental Protection Act 1994 and its subordinate legislation, which provides for a range of regulatory tools to ensure maintenance of ecologically sustainable development. So in your study guide, I've given you access to some website material. In particular, have a look at the Queensland Government Department of Environment and Heritage Protection website, which provides a list of subordinate legislation supporting the operation of the Environmental Protection Act. So one of those is the Environmental Protection Regulation 2008. You need to consider that and various policies that deal with environmental protection for air, noise and water. So if your property development is sensitive in any of those areas, one of the first things you need to do is to consider those policies, consider the regulations, and then consider the legislation. Not necessarily in that order, but it's not a bad way to go. Because if you're looking at the policies, you're looking at how these things are actually used in practice rather than necessarily the theory. So by having that stepped legislation, regulation, policy framework, you can see how the principles of, say, the principles of ecologically sustainable development filter down into a practical application. Previously, we talked about planning law. This week's concepts are very closely aligned with planning law because when we're talking about sustainability issues relative to property development and planning, we need to consider things like transport, ecology, site issues, and zoning and land use issues. Have a look at your text, Read and Sims at 11.8 in that regard for more commentary. And you'll see that there are certain things that are fundamentally important for a property developer to consider in that context that relate directly to a proposed property development. So, for example, when we're talking about sustainable development, we should also consider wider issues such as whether the property development that we have in mind improves and promotes walking and cycling, public transport. So if your development is geared up in such a way as to promote sustainable development by impacting the way in which your end users are likely to use your product, then you're more likely to be successful in your application for a property development. Also, things like how the transport might move around the property development and whether it integrates in the community in a fundamental way. So have a look at your textbook in that regard. Another practical thing that you need to consider are sustainability rating systems. So in your study guide, I've referred you to a number of sustainability rating tools. Here's where you need to look at the Green Building Council of Australia. The council uses Green Star as the rating tool. And if you look at the mission statement for the website for the Green Building Council Australia, it says, "We develop buildings, cities and communities that are healthy, livable, productive, resilient and sustainable. Our vision is to create healthy, resilient and positive places for people and the natural environment. Our purpose is to lead the sustainable transformation of Australia's built environment." Now, the reason I've read that for you in full is this. I want you to carefully consider those words and think about how, as a property developer, you can use those words to your advantage when you are coming up with concept plans, development applications, or if you have to go to court to deal with litigation issues. So come back to those fundamentals so that you have an answer, and it might even be a marketing tool. So an answer if queried, or a marketing tool to advance your cause. So I mentioned the case study, the Commonwealth Bank Place. This is a really interesting case study. This is through the Green Building Council of Australia website. In 2012, at a cost of $500 million, Commonwealth Bank Place created 58,000 square metres of commercial office space, and that was fully occupied by the Commonwealth Bank. It achieved a 6-star Green Star rating, and Green Star scored the building at 81 points out of a possible 100, which exceeded the Green 6-star benchmark of 75 points. So this is valuable because it provides you with very clear information about what the property developers did in that context to ensure such a high rating. And they considered sustainability from a number of perspectives. Firstly, there was a high performance facade, energy efficient lighting, heating, ventilation, air conditioning, rainwater harvesting and reuse, as well as other treatment systems. So what you need to do is consider all of these things and consider the likely greenhouse gas emissions from your proposed property development. So what does that mean when you're studying this unit? And what does it mean when you go beyond this unit into practice? Well, firstly, when you're doing your reading this week, when you're considering the material and the websites, firmly have in mind the 4 problems that I've set. That goes for each of the weeks. You need to be very mindful of the weekly review and tutorial questions, because they're the sorts of things that may well feature on an examination. So what I want you to do is come away from this week with some idea of what we mean by sustainable development. What do we mean by environmental protection? How do the two work together? How do governments and courts and decision makers generally recognise and accept essential elements of environmentally sustainable development? Beyond that, you need to understand how the concept of ecological sustainability relates to property development. In a concrete sense, have examples. Think about where you would source materials that would assist you in promoting a property development that is ecologically sustainable. Make it as real as you can. One of the ways to do that is to refer to, understand and use environmental assessment rating tools. So you need to understand, what are the main assessment rating tools used in Australia? How does that differ from overseas? And what purpose can you see the environmental assessment rating tools as serving for you as a property developer? Then finally, you need to consider how regulators use these tools to ensure compliance with principles of sustainable development. So when you finish this unit's reading, you should identify the sources of ecological sustainable development, appreciate the need to consider sustainable development as good practice in property development generally, and understand the rating tools and the regulatory tools to ensure and compel compliance with sustainable development. Thank you very much.